SJC-13654, Commonwealth versus David Njuguna.
Attorney Power.
Morning, Your Honors. May it please the Court, Andrew Power for Defendant David Njuguna. I'll begin with the question presented by the Court, Commonwealth versus Jones. Now, Commonwealth versus Jones is good law and should remain good law for three reasons. First, Jones construed the intent of the legislature, which has not repudiated that construction for 40 years. Second, the statutory scheme for motor vehicle homicide offenses supports the reasoning in Jones. And third, Commonwealth versus Vick, which the Commonwealth alleges abrogated Jones, actually cited Jones with approval. It did not abrogate Jones. Now, this court has repeatedly cited Jones as good law. According to Shepard's citation, this court has cited Jones in approximately 67 cases in total and in 13 cases since Vick was decided. This court has never stated that any part of Jones was abrogated or overruled in its citations.
And I think the appeals court, does a very thorough and well-informed reading of reading of the current law. My question is, what is Jones actually saying, and how do we take it and apply it? Because it doesn't give a lot of, it's sort of conclusory, and I'm just not sure what we take from it, because you're obviously going to want to apply Jones in other contexts. Okay, there's this kind of indication from the legislature that they don't want these two statutes to be prosecuted, even though they have different elements. But I just don't know how to do that. I know they say it in Jones, but is it time to either clarify or get rid of Jones? Because I don't know how you do Jones. Tell me how you do Jones, and particularly in another context. What are the principles underlying Jones, besides the fact that they say, okay, the legislature told us not to prosecute both of these, but they don't really explain why much either.
Right. And I think to understand Jones, you have to look at another case that's cited in my brief, Commonwealth versus Crocker, which was written by Chief Justice Hennessy the same year as Jones. Jones was issued in 81 and Crocker came out later in 81. And the relevant cases are Jones, Crocker, Commonwealth versus Alvarez as well. And the through line in those cases is that the Morey standard, which is really what Vick is stating, is a default standard of statutory interpretation. Where the legislature has expressed its intent as construed by this court, then that trumps the Morey standard.
I get the articulation of it. I just don't know how you do it.
Is this a one-off?
It can be, yes, and I think the appeals court realized that and discussed that as well. In most cases, this court has not construed an expression of legislative intent. And let's be frank, legislative intent is kind of a dialogue between this court and the legislature. This court construes legislative intent. The legislator is presumed to receive that construction and understand that construction. And if they don't act, they're presumed to acquiesce to that construction.
Right, but usually you discern this intent from, okay, the language isn't clear. We go look at the legislative history and it tells us, oh, we don't want double prosecutions here. They don't really do that in Jones. They just kind of say it. And maybe it's because there was, if you dig deep, that's evident. I'm just trying to figure out, is it, again, as Justice Gaziano says, a one-off, but like I read the amicus brief and it says, okay, we're going to do this elsewhere too. This isn't just a one-off that we're going to keep going with. It's a third way of proving, it's a third way of avoiding double prosecutions, right?
I think, yeah, under the reasoning in Crocker, it's the baseline for double jeopardy and for understanding whether the legislature intended double punishment for a given offense.
And how do we go about doing that? So I get it here, we have Jones, and you say Jones it applies here. How do we go about looking for this? Because it seems like it could open up a lot of different
Well, it's,
Vic problems,
I think
Vic
that-
exceptions.
I think if you go against Jones, that would also open problems with Commonwealth versus Alvarez, where this court determined that it was the legislature's intent to have double prosecution for a park zone or school zone violation and for the underlying drug offense, because that would clearly fall under the Morey test as lesser included. But this court said in Alvarez, no, there was expressions of legislative intent that we have discerned that the legislature intended double prosecutions in those cases, in this specific instance of a school zone violation and the underlying drug offense. So it's maybe a two-off.
It's double punishment, not
Double
prosecution.
punishment, exactly.
Right,
Double
so, okay,
prosecution is okay.
Right, so in the real world, someone is charged, like in this case, with involuntary manslaughter and motor vehicle homicide by negligence. That can go to the jury if they're convicted of involuntary manslaughter, which has a heftier penalty. They can be punished appropriately for that offense, correct? And not punished for the second offense.
Not for the other two offenses, correct. That's the holding in Jones.
Right.
And I think that's also consistent with the way the law has evolved as far as motor vehicle homicide offenses go. Jones explicitly said that the legislature came up with a motor vehicle homicide statute as a middle ground between driving to endanger and involuntary manslaughter. In the 40 years since then, we've seen a number of the legislature add a number of other offenses to the spectrum. I'd call it a ladder of culpability. And at the very top of the ladder, you have OUI manslaughter. So now it's not involuntary manslaughter that's the top. OUI manslaughter is at the very top of the ladder. And that's a 20-year felony with a 5-year mandatory minimum.
We could have second-degree murder if there was third-pronged malice, correct?
That's true too, but I'm thinking particularly within the motor vehicle context.
But, Counsel, I think this gets back to Justice Kafker's question. There's no question here that our job is to discern the legislature's intent. And so there's not really a problem about the double punishment scenario, because if the legislature's clear that they want double punishment, then double punishment it is. But the question is, with respect to what you're laying out for sort of the middle ground idea, because the problem is that there are a lot of areas where the legislature has laid out a number of crimes that are similar and that seem to escalate. And Jones reads the legislative history to mean that the legislature not only laid out a ladder of offenses, but actually intended that someone would not be convicted of the doubly convicted of both the greater and lesser, although they don't meet the test. So I think, can you go back to answering Justice Kafker's question about in what circumstances should we understand the legislature not to intend that a defendant be convicted of the higher crime also be guilty of the lower crime when there is a sort of escalating series of offenses like this?
I would limit it to motor vehicle offenses in Jones. I think Jones is, as the appeals court recognized, and I think as Justice Gaziano recognized, is a one-off where or a rare case, an outlier case, as Justice Nyman said, that's not intended, unless you discern an expression of legislative intent in the way it was constructed. In Jones, Chief Justice Hennessy looked at a memorandum from Endicott Peabody. I'm not sure exactly who that was.
Governor.
I think he was,
Who's the governor?
when this was enacted, I'm not sure. I checked, he was
He
governor in
looked
the
at a
60s.
signing statement by the governor, and that's where he got it from?
So it was a memorandum on there, yeah.
Okay.
So-
'Cause that's sort of problematic to discerning legislative intent when you rely on the governor's interpretation of the legislature,
Well,
a little bit.
it could be, but again, the legislature has the final say. And we see the legislature receiving this interpretation and acquiescing to it.
So
So-
it's it's an exceptional circumstance where there's a clear manifestation of the legislature's intent not to, because it's just odd. You know, I get it, and it may be a good thing as a policy matter, but it just murks up the Vic analysis, which was meant to clean this area of the law up, right? Vic is, works in a way that we, doesn't allow sort of a lot of fiddling. But you're basically saying stick with it as a one-off. This court's approved it in the past, and you don't need to worry about its spread to other areas.
Exactly, and I think the same with Alvarez. I think the Alvarez principle where double punishment is okay, notwithstanding the Maury standard, that's also one-off. So if you are going to overturn Jones, you would also have to overturn Alvarez and the park zone, school zone violation.
That's Chief Justice Gantz's opinion? Is
Alvarez, I don't believe it was 1992.
Oh, it's 92,
Yes.
okay.
If I have time, the other thing I'd say about Vic is that Vic is really nothing new. I mean, Vic simply restates the Maury standard, which goes back to 1871. And Vic is not a motor vehicle homicide case. Vic cites Jones with approval. In fact, you'll see Jones cited.
Vic is something new because it got rid of this looking at whether something's basically so unified, you shouldn't separate it out, right? Vic was a big deal when it came out.
But Vic said and made a big point about this is apart from a construction of legislative intent. This is where parties go beyond the intent of the legislature just to look at the facts of a particular case and to see whether the convictions or the charges are duplicative based alone on the facts. That was not the case in Jones. I think where it's maybe talismanic, but where you have intent of the legislature, where the court is putting it out as a construction of the intent of the legislature, that is different from the Vic situation where the parties are simply arguing it should be based on the facts, a duplicative offense.
If you don't mind, could you turn for a second to the sufficiency of the evidence on involuntary manslaughter?
Yes.
I would be interested in your view of your strongest case that there is insufficient evidence here of a conscious decision. I recognize, I've read all the cases cited in the briefs, and I'm just interested in your view on that.
Okay, my strongest case, I believe, is Hardy. The cases I rely on are DeSimone, Hendricks, Moore, and Guaman as contrasting with the facts in this case. In this case, you have somebody swerving 3 lanes across the highway into the breakdown lane and crashing. What is the articulable intentional act that caused the victim's death? Because that is one of the elements of the crime.
I mean, the tough thing in this case for you is that there's copious evidence that the defendant was driving recklessly before the crash. But the strange thing is that there's also very clear testimony that the road was totally clear in front of him when he swerved across 3 lanes of traffic and hit the trooper's car. And so it's not that he is in the midst of maneuvering dangerously when this occurs. He's in the passing lane with no cars in front of him and abruptly veers over to the right. So is there any case you've found where a person is plainly engaged in, I think here there's a record of at least 7 or 8 minutes of extremely reckless driving, but we sort of ignore that based on a circumstance like the clear road and the veering across the 3 lanes?
I would dispute the 7 to 8 minutes of reckless driving. I think you have an instance of reckless driving observed 7 to 8 minutes, let's say mile a minute, 7 to 8 miles away on the highway, and then nothing for 7 to 8 miles, no observations, and then this observation where he's passing without incident, and then in the left lane, and all of a sudden swerves over as if he, common sense, lost control, fell asleep, had a seizure, something inadvertent. This is an inadvertent situation, which is what takes us into Hardy. Inadvertency may be negligence, but it is certainly not wanton or reckless conduct. Now,
Even
in
if
the-
you're speeding at 80 miles an hour.
Even if you're speeding at 80 miles an hour, because it's, in Hardy, you have the woman failing to brake in time, swerving to avoid the other car, and then that precipitates the crash into the other lane. It's similar to that. Moore, Hendricks are cases where you do have consistently observed reckless conduct. So that would be, in those cases, there's a high-speed police chase. They're observing this person driving recklessly, and the high-speed police chase causes the crash. That would be the 7 to 8 minute scenario, but you don't have that in this case.
Thank you, Counsel.
Thank you, Your Honors.
Attorney Herron?
Good morning. May it please the court, Donna Marie Herron, Assistant District Attorney representing the Commonwealth. I asked this court to overrule the appeals court decision that the motor vehicle homicide conviction was a lesser included offense of the involuntary manslaughter conviction.
Can I ask you how this works in the real world?
Yes.
So a sentencing judge has this case in front of him, her, and they have involuntary manslaughter conviction, motor vehicle homicide by negligence, and the judge can sentence appropriately based upon the offense conduct in the record on the highest proven charge, correct?
Yes.
So what's the practical effect of what you're asking us to do?
The 15-year loss of license under the motor vehicle homicide statute that's mandatory, which is not mandatory under the involuntary manslaughter, as a practical matter for
Is
the
there any
Commonwealth.
loss of license in the motor vehicle, in the involuntary manslaughter?
There is no loss of license in the involuntary manslaughter, and particularly in the facts of this case, the Commonwealth would want a 15-year loss of license for Mr. Njuguna.
But if the defendant was actually convicted of both crimes, and then would there still be a basis for the license revocation if the lesser conviction were just vacated under double jeopardy principles?
We looked into this because of the appeals court ruling, and it's not a clear-cut avenue that we can go. We can petition the RMV to revoke as a dangerous, but it's not a clear-cut 15-year loss of license that the motor vehicle homicide conviction
So
gets
it's
us.
automatic under,
It's automatic under the motor vehicle homicide statute. It is not automatic, and I could not find a case on point which says, yes, you can do it. You'd have to petition the defendant as a dangerous person to try to get his license revoked. It wouldn't be automatic. So that is the Commonwealth's stake in wanting to have both convictions here. And I think Vic is not just a default. Vic made it crystal clear, this court in Vic, that to determine whether one conviction is a lesser included or duplicative of the other, we look to the elements. And this court actually discussed how their decisions previously in appeals court decisions were veering off and not following the strict element-based test. And this court specifically said, this is not what we intended. What we want is a Maury elements-based test to determine whether one conviction is a lesser included. And it's a clear way to know.
I get it, it's clear. Your brother, and I haven't gone back and reread this, your brother says that we actually cite Jones approvingly in Vic.
The language that says the Maury test should be the test to determine. That is the line that Vic quotes the Jones case. It says, as long as each offense requires proof of additional element that the other does not, and this is quoting Jones now, neither crime is a lesser included of the other, and convictions are deemed to be authorized by legislation and not duplicative. And that's what quotes the Jones case, which I actually found interesting.
You mumbled through the last
Oh,
part.
I'm sorry, and deemed to have been authorized by legislature and hence not duplicative.
Right,
They
but the
quote their-
problem is then Jones goes on to say, here, for whatever reason, we know that the legislature did not intend. So Vic is a test, Maury is a test to divine legislative intent.
Well, here,
And
I'm sorry.
and in Jones, the court said, be that as it may, we're not going to apply that test here because we know the intent is not to allow both of these.
The court actually in Jones first states that even though vehicle homicide is not a lesser included offense of manslaughter, we conclude in the present situation, which in fact did involve operation of a motor vehicle on a public way, the two offenses are so, quote, closely related as to preclude punishment on both. And then later on, it says, and we believe this follows the legislative intent to create a Miller crime, and I suggest Vic has effectively overruled that.
Have we cited Jones positively post-Vic?
You did in one case, which is what the appeals court cited, which is the Suero case.
Yeah.
And
How do you address that?
I don't think, with all due respect, that dicta in the Suero case overrules the clear intent and ruling of the Vic case. In Suero, that was where it was conceded, or was not challenged, that indecent assault and battery on a child was a lesser included offense of rape of a child. And the issue is whether the moving of the underwear was a sufficient distinct act to constitute indecent assault and battery. And that's the holding of that court, was that it was not, and that the indecent assault and battery conviction therefore was duplicative of the rape conviction. And then in dicta, the court does say, and it does quote the Jones case, but I would suggest.
And what does it say in that dicta?
So it says the prohibition against duplicative convictions ensures that the court does not exceed the legislative authorization by imposing multiple punishments for a single legislative defined offense. In other criminal contexts, this court has determined the legislator intended to punish conduct for 2 or more charges where they may have constituted one criminal act. And then it says C. Jones and the Kuklis, I know I'm going to say that wrong, I apologize, case. I would just suggest this dicta language in Suero does not overrule Vic, when Vic is crystal clear as to what this court intent was, and was crystal clear that we want a clear way to determine whether to.
Counsel, so the Vic test is basically a default rule that we use, that we created a long time ago, and we use because we need to sort of figure out what the legislature's intent is, and we don't have a report directly from the legislature about what their intent is. So we have devised this rule, which is, it's not actually a direct looking to the legislature and trying to discern their intent about a particular law. It's an objective test matching up the elements that we assume that the legislature knows that we apply, and so they will be legislating under the understanding of this long-standing rule. Because, however, our entire purpose is to see what the legislature intended, it seems to me that if there is evidence of the legislature's intent about whether a defendant would be convicted, of the legislature's intent, that has to override the default rule, does it not?
I don't read Vic as saying that. I don't read Vic as saying. I read.
I'm
Vic
not talking about Vic. I'm talking about what our task is, right? Our task. So are you saying that if the legislature wrote a statute that was very clear that a defendant could not be convicted of 2 offenses, they nevertheless could be if they didn't meet the Vic test?
I think because look, first, I think we can all agree that looking at the legislative intent can be difficult at best. And I think if the legislator clearly says, we want this, so say the legislator on motor vehicle homicide says clearly, if they wrote it and said, we do not, if the defendant is also convicted of involuntary manslaughter, we do not want them also convicted of motor vehicle homicide. No, I don't think I would have a leg on to stand to say, well, under Vic, they each have another one, does not. But when you get into this area of, well, what's the legislative intent? What do we, and it is going to open the door for other things. Defense counsels are not going to leave this at just the motor vehicle homicide or vehicle. It's going to open the door for other things. And I read an appeals court case recently, which I believe was a firearm, assault and battery is a firearm, and assault and battery causing serious bodily injury. And the argument using Jones was like, well, that was not legislative intent to create both, so it will be used for other.
When was Jones decided?
1981.
And now the parade of horribles is going to happen? I'm just wondering, that's your position.
That was an appeals court decision of 2020 or 2021, where I
So
believe
there's been
Justice
a
Rubin in his
reawakening
dissent.
of this Jones philosophy? Is that what you're suggesting?
I'm suggesting that
Or
this-
there will
oh,
be
sorry.
if we give our blessing again, we may
yes.
create that.
I do believe that is true, Your Honor, that if you say, yes, Jones is still a good law, and we abide by that, then that would open up.
But we have here the principles of stare decisis at play, do we not?
I'm sorry, I didn't understand your question.
We have principles of stare decisis here at play, do we not? Aren't we bound generally by our past precedent unless?
Yes, unless overruled, but in my reading of Vic, you did overrule it. I know you didn't expressly say, I am overruling, but the appeals court, and I cited it, and I get the appeals court in Njuguna disagrees, but in the appeals court in Irregular specifically says Jones has been.
You see, this is a vestige of the conduct-based test.
Yes,
That's what you're arguing.
that is my argument, because that is actually what Jones ruled, that this was based on the same conduct, and then goes into, we didn't think this is what the legislative intended, but it rules on the conduct-based test. That's what it ruled, that it was duplicative. And I suggest Vic has explicitly overruled that. And I think to make it easier and cleaner, this court should abide by the Vic rule and overturn the appeals court decision that Jones is an outlier and should be good law.
Was Suero, was that a conduct-based test also? Is that?
Well, no, we conceded that indecent assault and battery on a child was a lesser included offense, so they had to be based on separate or distinct acts because it clearly was a lesser included offense.
Okay, thank you, that's helpful.
If I may turn real quick to the insufficiency argument, there was one key element that wasn't discussed, and that was Sergeant Saratino's and Mr. Lindsay's testimony, both of them who said the defendant made distinct movements from the left lane to the right lane to the right lane, but more importantly, that he went over to the breakdown lane, straightened himself out, and then slammed into Trooper Clardy's cruiser. And I would suggest that shows reckless and wanton conduct and clearly shows the defendant was not having a medical episode.
Where does the marijuana use come into play?
I think that goes also to recklessness and wantonness, given that we know that Mr. Njuguna bought marijuana cigarettes from the dispensary, that he smoked at least one of them because we found a partial or pretty much the end of one. So we know he smoked that, and that I think also goes into the wanton and reckless conduct because he's smoking marijuana in a car while driving over 81 miles an hour. And as I said, Mr. Lindsay's testimony was that he was driving so fast it was though I was stopped, and he testified he was going 70 to 75 miles an hour. And Sergeant Saratino's testimony was the defendant rode the breakdown lane for enough time for him to think in his head, what is this guy doing? Is he going to pull over? Does he know the trooper? So in response to Judge Marcus's questions, he said he had enough time that Sergeant Saratino was having these thoughts in his head to saying, why is this guy not just pulling over? Why is he continuing to go straight? So that plus the continuous reckless and wanton conduct.
Could you address Justice Stewart's question, though? I just want to make sure I understand your response to that he had a clear pathway straight ahead. He's going 80, and he could have just kept going 80 straight ahead, but then he goes over. Do you have a factual response to that? Is that accurate, or how do we deal with that problem? Because it does seem odd that you would jet over to the slow speed lane when you can just put your pedal to the metal and keep going straight.
That was the testimony of the three cars. There was Mr. Russell, Sergeant Saratino, and Mr. Lindsay were the ones that observed the actual crash occur. And they all said he had a clear path. But as I said, they also, two others testified he could have stopped. And that was especially Sergeant Saratino's testimony. He didn't understand why he wasn't stopping. He was intentionally driving his car into the back, according to Sergeant Saratino's testimony, into the back of Trooper Clardy's cruiser. And he didn't understand why he believed that Mr. Njuguna, he said he wasn't understanding why he wasn't stopping. So I think that in itself would warrant, at the very least, wanton and reckless conduct in driving to affirm the involuntary manslaughter conviction. If there's no further questions, the Commonwealth will rest on its brief.
Thank you, Counsel.
Thank you very much.